So now I'm happy to introduce today's speaker, Clancy Catelin. She is an associate lawyer at Rosen Sunshine and a boutique health firm in Toronto. Clancy assists healthcare professionals, institutions, and individuals by providing advice and training on a variety of health-related legal matters, including medical assistance in dying. Clancy holds a degree in bioethics from the University of Toronto and completed her law degree at the University of Windsor. She articled with Sunnybrook Health Sciences Center's Legal Services Department and was called to the bar in 2019. Clancy is here to help answer and provide legal information, but not to give legal advice. So without further ado, I will stop sharing my screen and welcome Clancy. Thank you for joining us today to answer our questions about advanced care planning.
Thanks so much, Nicole, and that was a lovely introduction.
Thanks, Nicole, and thank you, Clancy, for joining us this afternoon, and to all of our attendees who are also tuning in from all across the country today. So to get us started, Clancy, we did have some questions about terminology, and we're wondering if you could clear some of that up, because there are a lot of different words that tend to float around when talking about advanced care planning. So could you explain what is advanced care planning? What's an advance directive? What's a living will? How do these things all work together, or what are the differences between them?
Sure. So if we're looking at advanced care planning, let's think of that as the umbrella. It's more about the process. This is what all of these other terms sort of fall within. So part of your advanced care planning may include an advance directive. It may include a living will. It depends really on your circumstances and where you live. And the terminology used, I think, as Nicole helpfully pointed out, does change where you live as well. So sometimes that's responsible for some of the confusion about terms used. I do know that one sticking point for a lot of health law lawyers is the use of the term POA when we mean substitute decision maker. And part of the reason that that happens is because your power of attorney can be your substitute decision maker. This is someone that you appoint through a legal process into that role. So when you get asked maybe at a hospital, who's your POA, they're really asking you who your substitute decision maker is. And those terms have unfortunately become a bit interchangeable. When we're talking about the advanced directive, it depends on where you are. You might have a different term, but in Ontario, your advance directive is usually something that you put into writing that expresses your wishes about care. It expresses maybe some of your values that would inform decision-making going forward, treatments that you do or do not want to pursue. And it may also say who you would like involved in decision-making or care, and may be accompanied by a power of attorney form assigning a specific person as your substitute decision maker. What's very helpful with the kit that Dying with Dignity's put together is that there are instructions for each province. So if you're not in Ontario, unfortunately, that is my area of expertise. Go have a look at your form and it'll tell you a bit more.
Great, thank you. It's very helpful. And can you clarify when the information in an advanced directive is used, or when any of these advanced care planning preparations come into effect?
Sure. So these are all being prepared in the event that you are no longer able to make decisions for yourself. And that is when these, depending on where you are, different names, but this is when these documents really come into play and when your substitute decision maker steps into that role of making decisions for you.
Perfect, thanks, Clancy. Okay, so now just some general questions about advanced care planning. What are the top three reasons why someone should write an advanced care plan or go through an advanced care plan, write an advance directive?
Sure. This one maybe not even a strictly legal question, so feel free to jump in and add your own. But I think one of the main reasons would be to understand for yourself what your wishes are, and to really take that time and put some thought, because we really don't know when we'll become injured or ill, and it can be uncomfortable, but it can also be very affirming to put some thought into this area. The other main reason, of course, is to communicate those wishes to others, so that if you do become unable to communicate those wishes or make your own decisions, that the people who are going to be stepping into these roles, your healthcare providers or your substitute decision makers, family and friends, are able to fill those roles and understand your decisions. And personally, I think one of the biggest reasons to do this is that it's such a gift to the people who have to step into those roles, and it can really provide, I think, a lot of comfort and assistance, even to say something as simple as where you would want to live, or what kind of service you would like after you pass. All of these things can be a real source of stress for the people in your life.
Absolutely. And I think you kind of answered my next question when you noted that we don't know when we're going to get ill or have an accident. And so I was going to ask, when is the best time to complete an ACP kit? How early should you, if you're in your 20s or 30s, should you be completing an ACP kit? But I think just that note itself that you said, I think that covers it, that really anyone over the age of 18 should have some form of direction in place.
Oh, absolutely. And I know maybe it's not the most glamorous project, but it is something that you can do with a friend or a family member, and really, it's more interesting, I think, than people anticipate, and it's worth doing.
Yeah. So when you're involved in advanced care planning, when you're creating some of the documents involved, does a lawyer need to be involved in that process? Do they need to notarize documents, for instance, or be involved in any of those discussions or decisions that are made?
Mm-hmm. Generally, no. I would say that everyone's circumstances are different, and more complex circumstances may require the advice of a lawyer. For the average person, the government has, for example, in Quebec, they've completed a very holistic way of doing this through the government. In Ontario, we have a standard power of attorney form. A lot of different provinces have this kind of thing in place, and that is really to make this easier and to make it very clear what you're supposed to do in the absence of a lawyer. And the Dying with Dignity forms, I think, do a great job at that as well. But as I said, there are situations where you might need more advice, especially if you're looking maybe at more estate planning issues. I think that that's always a good time to consult a lawyer.
Thank you. And can a family member override somebody's wishes that they've laid out in their advance directive? And does it make a difference if that family member is the person that's been assigned as the POA or the substitute decision maker?
Well, it does make a difference, absolutely. So conflict within families in these kinds of situations does happen. And I think that having this kind of a plan in place can really help to minimize that. But aside from that, back to your question, only your substitute decision maker has that authority to step into the role of making decisions for you, and their decision will take the place of other family members' decisions. I don't want to say whether they like it or not, but that is the case. It's more complicated in practice, I'm sure, but legally speaking, it is that simple. When you have a family member, or let's just stick with substitute decision maker, when they are making a decision that is not respecting your wishes, not following your wishes, that is quite serious, and they're not permitted to do that. In Ontario, we have a specialized board that deals with this type of issue. It's the Consent and Capacity Board. A family member can apply to this board if a health professional is not willing to follow wishes. A health professional can also report a substitute decision maker to this board and seek their assistance. So we do have resources in place because these disputes do happen, but legally speaking, wishes should be respected when possible.
That's good to know, and you know, something that I think a lot of people do worry about. So that's good. And it also actually leads into my next question very nicely, which is, how is it determined whether or not someone has capacity to make their own decisions? At what point does the substitute decision maker get called upon to step in and start making those decisions?
Right. This is one of the more complex areas. That the law is centered around two main questions in terms of capacity, which is whether you're able to understand the information about the decision and whether you appreciate the consequences or the follow-up of what that decision actually entails. So whether that is the case can be as simple as the person is unconscious. That's very simple. You cannot make a decision. You do not have the capacity to make a decision. And it can range to very complex cases where perhaps somebody has a good day and they're very capable of understanding and appreciating and able to make decisions, and someone might have a bad day. So consent and capacity law is quite complex in that respect, and that's when you are really going to be relying on your health professionals to make these assessments. They're not assessments that should be made by a layperson.
Okay, thank you. My next question, kind of, maybe it's not as straightforward. I was going to ask, how is advanced care planning different across the provinces? I know we already talked about terminology, and I know you're based in Ontario, but do the rules, I guess, change, do you know, across the provinces?
Yeah, this is something I've looked at before, so I don't mind commenting. They do change. A lot of different requirements in terms of what's going to make for a valid advance directive. Different provinces have different requirements for witnessing, different requirements for who can act as a witness, who cannot. Some provinces have registries, which are great because then a health professional doesn't need to know you. They can go look up your advance directive, but other provinces don't. Ontario does not. There are a lot of differences in that respect. There are also differences in how you can appoint a substitute decision maker, and that is part of why you really want to be careful and use the right resources for your province, because you don't want to go through all this work and have an inadequate tool going forward.
That makes sense. Thank you. So how often should I update my advanced care planning documentation? Is there a general guideline for how often that should be done, or different situations that should trigger somebody to review and make some updates?
So what we would usually say is you want to do this regularly. Regularly to me means every 1 to 3 years. And what I think you've touched on already is that you really should be looking at this and at the decisions that you've made before. Every time you have a significant change in your health, significant change maybe in your life or in the people who are in your life, there's also, it's really helpful, I think, to update it with discussions with your health professionals. And it's a good opportunity to look at it again together, especially if you're coming into a new diagnosis, or perhaps you become aware of some family history, that sort of things. There are a lot of things that could trigger that. And keeping it updated is very important for demonstrating that these are still reflective of the decisions that you would make, or the wishes that you have. So you're quite right. It's very important to do this regularly, and also to look at it anytime something important changes that touches on the document.
Right, for sure. And some people have had situations where the person that they've appointed as their substitute decision maker has died. So obviously that's another, it's not about your personal health situation, but somebody else's health situation may have changed that then affects their ability to act on your behalf potentially.
That's quite right. Or even maybe they don't pass away. Maybe they're going on a world trip and they're not going to be accessible. Little things like that too. It might not occur to you, but you really do want these people to be readily available in case you need them.
Sure. Yeah, lots to consider, lots of factors. So the next question is, does advanced care planning and the documents involved with advanced care planning, does that include do not resuscitate orders? Could you speak a little bit to those?
Sure. Do not resuscitate orders generally have a form that they take. Most provinces have a designated form that they would like these to come in. They need to be signed off on by a health professional, and they should be dealt with in collaboration with the health professional. So that's a little different than the Advance Directive that you'll be looking at if you go and do some work with the Dying with Dignity forms. But what you can do is discuss your wishes around resuscitation. You could make it clear that you, in a certain situation, would not like to be resuscitated, but that is not the same thing as a formal DNR order that would be kept in your medical record.
Perfect, thank you. Okay, next question is about where I should keep my advanced care planning kit, my documents. Should I make copies? I know you mentioned having conversations with your healthcare professional, and a lot of people ask, do I need to bring my documents to a lawyer? So can you just speak a little bit about who should have copies and where they're best kept?
Right. I don't think it's generally necessary to give them to a lawyer. That might be a convenient thing depending on how your life is organized and managed, right? Maybe they are the person that your family would go to see to get that kind of information. But in general, I think the goal is to have the people who are referenced in the document be really aware of it. You'd like your substitute decision maker ideally to, they don't in all provinces have to agree ahead of time. Some provinces you do, but it's certainly good for them to know that you have this expectation that they will step into that role. So you'd like them to have a copy. I think it's very helpful for them to have one. Not just for their own reference, but also if they need to provide it to a healthcare professional down the road or other family members if they can't find your own. You also, I think it's great to give it to your primary physician, or if you are working with a team or you have a particular hospital that has a record on you, you might want to ask them to include that in your medical record so it's readily available. And then in terms of keeping it for yourself, it's good to keep these sorts of forms together. Say if you have if you do have a signed DNR order and you have your POA and you have your Advance Directive, you might like to keep them all together in a folder. Perhaps that's brightly colored, clearly marked, and you could put a note either on your fridge or in the entryway of your home that clearly identifies where that is. And that's just going to make it easier for any first responders to find one. Some provinces have programs. I believe Alberta, and I could be mistaken, has a program where they will send you a particular color of folder, and there's a specific notice and a specific place that they will look for this. So you want to have a look in your own area and see if they have a program like that. And I think aside from that, those are the places I would say you want to cover for sure.
Thank you. Yeah, I think you're referring to the Green Sleeve program
Yes,
in
that's
Alberta.
right.
Yeah, and a lot of our supporters in Alberta will use that and let us know how that goes on their end. So that's an initiative to look into if you are in Alberta. So we have a few questions specific to substitute decision makers. And this one is about situations where somebody has multiple children, adult children. Should I pick one adult child to be my substitute decision maker, or should I give all of my 2 or 3 or multiple children the same decision making authority, or are there pros and cons to consider with that?
Yeah, and I can see why someone would gravitate towards that, not wanting to maybe put it all on one person, or to pick a favorite or anything like that. But the main problem is that if you appoint more than one to act together, that they need to agree, and they don't just need to agree, they also have to act together. So if one is not reachable, that can really slow down the process. So it's just practically not a great option. What you can do while still having everyone involved, you can specify that one is a primary substitute decision maker and that another or a sequence of others are secondary to that person, so that if one person becomes unavailable, they can go down to the second. You can also include other instructions in a POA form in Ontario. You could specify, for example, that you would like your primary substitute decision maker power of attorney to consult with other people. But really, it's best if only one person is bearing that responsibility, just to help make decisions more efficient.
And I've heard of some people deciding that they might have one child be the person who's deciding about healthcare, and then another the person to decide about financial stuff and estate and that kind of thing. Does that happen quite a bit, or does that lead to issues, or is it typically okay if things are sort of divided up in terms of responsibility that way?
Well, I don't want to speak too much about issues. It's not really an area of expertise that I have. Maybe you've heard some stories, but in terms of whether you can do it or not, absolutely you can. Ontario divides these conceptually and in forms. You have a power of attorney for personal care, and that's around the healthcare decisions, and you can have a power of attorney for finances. And so those are already conceptually distinct in Ontario, which makes it very easy to do. I think similar principles apply, that you would like to have one person responsible in either case, but whether or not they're the same person, I think is really up to you.
Thank you. So this is a very popular question. We've gotten this a lot just in preparation for this webinar, and it does come up quite a bit from people who reach out to us. So does your substitute decision maker for healthcare, since we're focusing on healthcare during this session, do they need to live in the same city or province as me? And could they potentially live in another place? We get a lot of people who say, my adult child lives in the US. Can they be my substitute decision maker?
Right. So yes, the simple answer is yes. You can have, there's no real restriction on that. You do want to do maybe a basic check to see if there are any other laws that interact with that responsibility. You also want to look just at the different provinces have different eligibility requirements for substitute decision makers, and those are good to familiarize yourself with as well. But where they are is not as important as whether they are reachable and whether they can communicate with healthcare providers to provide them with the decisions that they need to make, and to I think we touched on this a bit earlier, that if someone's not going to be available, you really should be making a plan to have someone else be available, because it could be that they're needed right away. Otherwise, or to have a backup in place is also good.
Yeah, again, just seems like preparing for the unpredictable, right? Somebody might end up on vacation and they're in the middle of a jungle somewhere, you know, they can't get a phone call from an emergency room if something were to happen. So
absolutely.
Yeah, it makes sense. Okay, so another question about SDMs. What if I don't have any trusted family members or friends to act as my SDM? Is there something in place? Is there a resource or an organization that folks could be referred to?
So the government steps into this role through the Office of the Public Guardian and Trustee. And that, I think the name may change from place to place, but in Ontario, that's certainly the case. Also, in Ontario and many other provinces, they establish what we call a hierarchy of substitute decision makers. So even if you have not assigned someone, and this is not in all cases, but in most cases, they start, let's say, with your spouse, and they work their way down through your relations. And if there is no one else on that list to act for you, the last person on that list is the public guardian and trustee. And that's a real safety net. You're not going to be left with no one to assist you in these circumstances. But that said, there are a lot of benefits to having someone else step into that role. If you can find someone, I would recommend that instead.
Perfect, thank you. Okay, so I want to switch the conversation a little bit now to talk about one of our most asked about questions and topics, and that is advanced care planning and medical assistance in dying. So can I put in my advance directive that I wish to end my life with MAID if I get, you know, a dementia diagnosis or something like that, even if my quality of life declines? Can I put that in my advance directive?
So no, the short answer is no. You're not able to make that request at this time. What you can do, you can still put it in there if you would like to. It's not legally possible. It's not something that your substitute decision maker can consent to on your behalf. So this is an issue that the government is still looking at that may shift over time. They have made a commitment to look at this issue, so we'll see what they say in coming years. But it is a really big area of concern for people. And so I understand why that does come up. One thing that you can look at, and that hopefully you'll learn a bit more about as you go through the kit, is that there are other decisions that can be made in place of a MAID decision. And those include, we've talked about DNR. So let's say that if my quality of life is at a certain level, I would like to not have heroic measures, sometimes people will say, to preserve my life. I would not like artificial hydration or nutrition. I would not like mechanical breathing. So these are all, or even certain medications. You can refuse antibiotics. These are all, I hesitate to say strategies, but these are all ways that people have asserted their choice not to prolong their life if they're in these conditions.
Right, and you kind of just touched on it a little bit now, because the government is looking at MAID and advanced requests right now. So people want to know that, assuming it is possible in the future to put this in an advanced directive, is there something folks can write now? And I know in the kit there is a spot in the Dying with Dignity kit. There is a spot to write your wishes around MAID. Is there anything else you would include? I think you just touched on it really well, but I don't know if there's any other guidance.
Yeah. So when you're working through this kit, I think something that you'll find is that there's a big focus on really communicating your values and communicating, because you don't know what situations you're going to find yourself in. We don't know if it will be legal in X amount of years for your substitute decision maker to act on your wishes. And it doesn't invalidate your advance directive to put it in there. So that you can put it in there, as you pointed out, the forms do include somewhere for you to discuss MAID now. It also, I think, can help just reinforce to the people making decisions on your behalf what your values are. And I think even if they can't act on that particular request, it might help them understand your wishes better. So I would err on the side of including more information about your wishes.
That makes sense. And I think, like you said, it's difficult to plan for every single medical situation, but giving a sense of values and beliefs can really help to guide those who are making those decisions. So certainly good advice. Do you have any suggestions for how to get my advanced care planning documents witnessed if I'm housebound? And a lot of us are more housebound than usual given the pandemic and restrictions that are in place. So do you have any recommendations for that, or do you know if that can be done virtually?
Yes, so that can be done virtually. The legal system in Canada has taken a lot of steps to try and keep things moving as we are in this exceptional circumstance. Some lower tech options include through a glass door or through a window. People have been very creative. And these are all valid ways of doing that, of having a witness signature.
Thank you. And we've tried to pivot a lot as well with some of our programs as well, with witnessing MAID documentation through Windows and virtually. So it's good to hear that that applies to advanced care planning documents as well. So do you have any suggestions or advice about speaking to family and friends about, and especially those who you might assign to be your substitute decision maker, about end of life wishes? It can be, of course, a very emotionally charged conversation, and people can sometimes struggle with how to approach that.
Yeah. Well, I think that the approach is going to vary as much as people vary. So it's worth putting some thought into. If you know that you have a supporter, you could ask them to come with you if you think a conversation is going to be particularly difficult. You can take steps to make sure that the other person is comfortable. Maybe don't do it at family dinner where everyone can bring in their point of view when you would rather it be a one-on-one conversation. You could ask them to do the planning with you. Maybe that's the kind of relationship you have. I think it really does depend. But these conversations are difficult, but they don't have to be negative. I think that there are a lot of ways to look at it as something more positive and just could bring you closer, I think. And again, this isn't legal advice. This is really, it's hard to say. It's interpersonal. And I think just approach it sensitively and do your best. If you don't succeed, maybe get some support.
Perfect. Thanks, Clancy. It is a hard discussion to have. So, you know, you kind of have to approach it with specific to your loved ones and whoever your substitute decision maker is. Absolutely. We have a question about if someone, you know, goes to a hospital and they're worried that their wishes will not be followed in an emergency situation. Is there anything they can do? I know you mentioned some provinces have a database where people, you know, put in their advance directives and they can pull that up. So that's great. But is there anything else people can do other than, you know, assigning a substitute decision maker to be sure that in those situations their wishes would be followed?
Yeah, I have a few thoughts on this one. I think that it's worth noting that I think a lot of the stories about wishes not being followed are in part because of emergency situations and because there isn't that opportunity to communicate. So in the absence of knowing your wishes, the decisions made in an emergency may be made on your best interest and not with your consent or with knowledge of your wishes or your substitute decision maker's consent. Outside of an emergency situation, this should not be a problem, and if it is, that is a professional issue, and I would seek some support even within the hospital. A lot of hospitals have patient experience office or something like that could help you if you're having difficulty with a particular professional. Also, when we're talking about the emergency situation, it is the case that a professional should not be providing care if they know it's against your wishes. So finding a way to get that information front and center in an emergency is not so simple. We have talked about some strategies like having things ready to go in a prominent place in your home so that if you get picked up by an ambulance that comes to the hospital with you, that's great if that happens. If it doesn't happen, they might not get that information. And while that's unfortunate, they're doing their best. So there's no intention. I think that's what I want to communicate. There's generally not an intention on the behalf of health professionals not to follow your wishes. And maybe I could dig it up after this and send it to you. You could include it in the resources. There are some very prominent, well-known cases where health professionals have really paid quite severely for not following these wishes. In one case, a woman who was a Jehovah's Witness had a card identifying her as someone who did not want to receive blood products, and they proceeded anyway because they didn't, for whatever reason, feel that they could go without providing that care. And I believe they were, the woman did win in her civil suit against that physician, and I think it was somewhere around $20,000. So it certainly has made an impression, and things have changed in light of cases like that. And that does provide an idea. You could put a card in your wallet. You can communicate ahead of time with your local hospital if you are in a situation that allows that. That doesn't work so well maybe in Toronto, where you could end up at any number of hospitals, but in a smaller community, I think it'd be worth doing.
Thanks, that's helpful. And a question that sort of ties into that is related to DNRs. And somebody asked, I've heard that paramedics won't go searching for a DNR. And I think what we've been told quite often is that, no, if a DNR is buried in a drawer somewhere, paramedics not going to know, oh, I'm going to check every drawer in this house and try to find it, because they are going to default to trying to save that person's life if there's no document that says otherwise. So, what we typically say is the fridge or what you've mentioned right in the doorway when they're coming in is a good place to keep those documents. But the documents are only as good as where, if they're able to be found. Is that be accurate?
Yeah, that is accurate. And I suppose the other thing that goes on that, other people who live with you, you could make sure that they know where they are, because they might be in a position to give those documents to EMTs.
And another question. So if I'm having a lot of conversations with my family, with my substitute decision maker, we talk about end of life and, care and what I would want or not want quite often, do I still need to fill out an advance directive that outlines what that care is? Is there still value in doing that, even if I'm having a lot of conversations?
Yes, there are a few different ways that it can play a pretty important role. It can act as confirmation of those wishes if your substitute decision maker needs to show them to someone else. And I think even if you're having these conversations in a high pressure situation like an emergency, I think that it's still really valuable to have those set out somewhere clearly for your substitute decision maker as a resource for them. And in some areas, you are going to need some sort of documentation to assign the person that you want as your substitute decision maker. That may or may not be your advance directive, and that's very much dependent on where you live and what forms you have to use. But those are all reasons to do this. And it really just, I think it can help solidify your ideas and maybe turn your mind to some situations you haven't considered yet.
Perfect, thank you. I couldn't unmute myself there. Okay, we're going to, I'm just looking at some of the audience questions. We've had a lot come through. I think one thing, and I know we touched on this at the very, very beginning, maybe some folks missed it, but there seems to be some confusion still around what is an advance directive and what is a living will. And my understanding is that the term living will is a little bit more of an American used term. Is that correct, Clancy?
Yeah, that I think is a pretty succinct way of putting it. And, even in Canada, the terms really do shift. The terms for substitute decision maker, some people have a guardian, some people have a proxy, some people have a mandateur. Like it really goes around. So I wouldn't pick, they are filling the same role, and that's what's important. So depending on where you live, be a different term. And I agree, living will is really more of an American item. I suppose it's possible to create a document and call it a living will with your lawyer if you want to, but it fills the same role.
Right. Thank you. Just having a look at some of the other questions that have come in. Sorry, there's so many. Some of them, I think we've touched on most of them. Kelsey, do you see any that stick out to you?
Yeah, I can jump in with a couple. Maybe we'll combine these two, but there's some questions that are related to bracelets, bracelets that say, I don't want to be resuscitated. And if those are valid and what paramedics and other emergency service folks would do with those. And then the other question that ties into that is a lot of phones, cell phones these days will have an emergency thing on the phone so that people can access your emergency contacts and you can put in your blood type and that kind of thing. How can those be used to better make sure your wishes are known for healthcare in the event that you don't have capacity?
Yeah, I think that's a very creative way to express your wishes. And again, this may be a little different in other provinces. In Ontario, your wishes do not have to be expressed in a particular form. We recommend the form to do it in writing because that's clear and easily confirmed and given to other people. But for example, if you had an advance directive and the next day you had a conversation with your substitute decision maker that said something else, the most recent expressed wish is what they're going to be held to. So you can express your wishes orally, you can express them in writing. I see no reason you couldn't express them on the lock screen of your phone or on a bracelet. There is a question about how a health professional will assess those and whether they'll feel that it's a strong enough indication if it's a life or death situation. And that's a decision that health professional is going to have to make. But I certainly, I don't see why you couldn't take those steps, especially if this is important to you. Every little bit might help. So,
and we've heard that that the bracelet thing, and people have brought up tattoos saying DNR, that these won't carry the same weight, that sort of the DNR is a very big exception, and that even if you have it tattooed on you or all over the place on various documents, it has to be that official document from a healthcare provider that will actually be honored if a paramedic, say, comes into your house and you need to be resuscitated. Is that right?
Yeah, well, they've put a DNR order into a form for a reason. They really do want it to be something that is signed off on by a healthcare professional because, I think it's really important that people understand what they're actually refusing. And that's a big part of it. And also to have someone else confirming that this is a legitimate request and confirming, let's say, the identity and the capacity and the I want to say lack of coercion. I feel like that might be a bit heavy for what I mean, but having that there is a bit of a safety net for healthcare professionals. So if they have something that they can look at that confirms that the request came from you, they can clearly see when the request was made. All of these things help to formalize it. And I would agree that's the way to do it. If you take this seriously and you want this to happen, that's what you want to do.
Perfect. Thank you. We have a question, and I've received this question over email before. Can a person's lawyer act as their substitute decision maker?
No.
Okay.
This is I think that would be quite tricky. There are some situations where you, I think, could put a trustee in place, but that's not really my area of law, so I'm not going to comment on that. It would be inappropriate for me to take that role for someone.
Right.
So I'm going to say no.
Okay, perfect. Thank you. I'm seeing a lot of questions that are quite personal in nature in the Q&A. So again, we're not going to be responding to any of those, but please email them to support@dyingwithdignitycanada.ca, and we can follow up with you directly. Kelsey, do you have any more questions on your end?
Maybe just another clarifying question related to the hierarchy of who decides in the event that you don't have a document in place. So is it fair to say that by filling out your power of attorney for healthcare, that's an added, I guess, piece of security? So you're 100% sure that there won't be any problems with whoever you've written down being the one to make those decisions on your behalf, and also a way to ensure that if you do have an issue with the person who's at the top of that hierarchy and you don't want them for some reason, then you're sort of giving yourself some comfort that they won't be chosen. So I don't want my husband to decide for me. I want my child to decide for me. Then I can be more sure that that will actually be followed. Is that correct?
Yeah, that's absolutely right. So anytime that you're taking a step out of, let's say the family hierarchy that's provided. So and this is because I didn't go into much detail. The top of the hierarchy is your POA or other court appointed person in that role. Also, someone appointed by the Consent Capacity Board in that role. And then we get into family, the hierarchy within a family. And then at the very bottom, we have the public guardian and trustee. So that is accurate. By assigning someone under power of attorney, you are putting them right at the top of the list, no question about it. And absolutely, if you have concerns about who's going to step into that role, very, very important to get a power of attorney in place.
And you mentioned the Consent and Capacity Board in Ontario. Mm-hmm. Do other provinces have something similar, in most provinces at least?
Yeah, many do, some don't. The Consent and Capacity Board provides a real range of services that are really helpful in Ontario. I'm not as familiar with their roles in other provinces, but I do believe that they're similar because capacity issues really are so fraught and complex. They're an important resource to the individuals who are having assessments made and who would like to contest those assessments, also to family members and healthcare providers in dealing with that role of the substitute decision maker and what they can and cannot do. And whether it's in line with others' wishes.
Perfect, thank you. I just actually have want to clarify one more point of clarification, I guess, on something we touched on earlier. Maybe some folks missed it, but you had said that you don't need to get your forms, your advanced care planning forms, notarized or witnessed by a lawyer specifically, unless you're maybe dealing with a more complex issue. But the forms, the Advance Directive, the assigning a substitute decision maker, those forms do need to be witnessed, correct? Not by a lawyer, but by another individual?
It varies.
Okay.
It does vary. The instructions are very clear on each of the forms that Dying with Dignity is provided. So I really do strongly recommend that make sure that you're using the right one for where you live and that you read those instructions carefully. Witnesses, sometimes it's not always common sense to you or intuitive to you who can and cannot act as a witness. So it is important to check those requirements as well. Some places do not require a witness. Some places require two. So, it's really just dependent on where you live.
Okay. And we're going to be sending out, you referenced the Dying with Dignity forms again, and we're going to be sending out a follow-up email following today's session. It won't be right after, but in the coming days, and we'll include the links to the kits on the website and the forms and some of the resources that Clancy noted as well. So that will be coming out along with a link of today's recording in the coming days, possibly next week. So Kelsey, do you have any final questions before we let Clancy go?
I think this was really helpful, and we have lots of great comments of gratitude coming in, and I just wanted to echo that. We're so glad that you could join us this afternoon and share all your knowledge with us, Clancy.
Mm-hmm.
Well, thank you so much. Happy to join you today, and always glad to help when I can.
Awesome. Thank you so much. And thanks to everyone for coming out and watching today. Have a great afternoon and stay safe, everyone. Thanks so much. Bye.